Call the meeting to order at 9 a.m. on the 7th of October. First item is the roll call for the members. Dr. Drake is not here today. Dr. Bazzini?
Here.
Dr. Coble?
Here.
Mr. Daniel?
Yes.
Dr. Downing?
Here.
Dr. Kerrigan?
Here.
Mr. Parsons?
Here.
Okay, that's item number one. Item number two is to discuss, briefly give a small bio of a former presiding chairman, Dr. Vince DeMayo. Dr. DeMayo was born in Brooklyn, New York on March 22nd, 1941. He graduated from New York's Downstate Medical College in 1965, after which he served as a major in the Army as the chief of the legal medicine section and the chief of the wound ballistics section at the Armed Force Institute of Pathology in Washington, D.C. He then served as medical examiner in Dallas from July 1972 to February 1981. He then moved to San Antonio to become the chief for Bexar County, a position he held for 25 years. After his retirement, he was appointed by Governor Perry to the Texas Forensic Science Commission and by President Obama to the National Commission on Forensic Science. Although he grew up in New York, he loved being a Texan. He was most proud when Bexar County Forensic Science Center was named after him in 2018. During his time with the Commission, Dr. DeMayo led numerous impactful reforms, including the development of forensic licensing program and the adoption of the report regarding bite mark comparison in the Steve Mark Cheney case. Dr. DeMayo was not shy about sharing the accomplishments of the Commission at national meetings he attended. One of his most frequently cited quotes, as he told Mike Hall at the Texas Monthly, was that we're so far ahead, everyone else is eating our dust. There's no doubt he would say that. He was a colleague, he was respected. We disagreed on certain things, but then when we would get talking about policies, we found that we agreed on about everything. So if I could have everyone observe a moment of silence. All right, thank you. Item number 3 is the announcement that Dr. Bedoli has retired from the Commission due to his residence requirement. Currently, there is not a person in that position, although the Governor's office is investigating that, so we don't really have any idea of when there will be a new appointment made.
One small thing on that, Dr. Bernard, is that Dr. Coble was recently named the permanent director. He was interim, and now he's permanently appointed as the director of the CHI, and so that means he will be moving into that seat and out of the general forensic expert seat. So whoever fills the new seat will be someone that the Governor's office designates. They just haven't done that yet.
So permanent's like for the rest of his life?
Permanent.
You got to do it. Permanent. You can't leave.
Well,
I think
Wow.
he could leave.
we think we should congratulate you.
Yeah.
There's always something else tied to it.
Condolences he doing.
All right, item number 4 is the review and adopt the minutes from the previous meeting on July 22nd, 2022. Do I have a motion to approve the minutes?
So moved.
Second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. All right, next item is the administrative office update.
So we do have a new budget in your materials to approve for FY 2023. One of the items that we've built into that we wanted to talk to you about is funds to allow some lab directors to attend the National Forensic Science Academy, which is a collaboration between RTI and ASCLD, and that is a 3-tiered management certification. There's a supervisor level, a manager level, and then an executive, lab executive type level. One of the reasons that we built that in is because we've received feedback that it's a really good program, and a number of our lab directors and quality managers have asked the Commission to consider building a license for management. A number of them have said they would like to be licensed because their analysts are licensed. So this might be a way to see whether attending that certification program could be a threshold entry point for a licensure and a management program where we would, if we were to develop one. It's not in the immediate list of priorities for us, but it's sort of on the horizon. I know a lot of you know Jody Wolf from the Phoenix Police Department Laboratory. She has been instrumental in sort of creating and developing this certification program. A number of people from DPS have gone through that. I don't know, have you?
Yes.
And do you have any feedback about how it was?
Yeah, it's a great program.
Yeah.
Leadership Academy, that's not, really good.
Okay, so I think the feedback we've gotten is DPS has funded a bunch of people to go through it, but the question is, like, what about the other labs? Do they really have the money to do it? So we're not thinking of funding probably $30,000 worth right away, but up to that. You know, I think the tuition, they will create a class for Texas. And the Texas class can be tailored to include things that aren't in the current certification, such as, you know, legal disclosure issues that are particular to Texas, things like that. So our hope is that we can work something out with them to support our managers in achieving that certification.
It's a really great initiative, and I'm excited to hear that it would be a Texas class as well, rather than the regular class. The regular class is great. I think it's a super idea. I wanted to just mention that this year we have an initiative through the Institute, and our doctoral students are all going through the S-Cloud Leadership Academy right now, our graduating PhDs. So it's a fantastic opportunity. But I think the labs sadly don't have the resource to do that. So.
We'd like to support them in that.
100%.
So we need a vote on that.
On the budget
Yeah.
altogether.
All right, so are there any questions regarding the budget? All right, do I have a motion to accept the budget as proposed?
So moved.
Second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
The next thing I would just add is that we continue to struggle with the competing priorities that our programmers have. They were just given two major Texas Supreme Court projects with legislative deadlines that they cannot get around. So every time that happens, our work gets set aside. We do have right now Lee and Rodney sort of begged, maybe a strong word, but tried to convince folks that if they could at least release the licensing portion, that would be very helpful, in part because Rodney's doing double the work right now. He's still maintaining all of his Excel spreadsheets of all the information for each and every person and using the database. So we're trying to phase out of that, especially because we're coming into one of the biggest rush times that we have, which is renewal. It happens every 2 years in the last 3 months of the second year. So we will give you another update on that in January. Did you have anything else?
No.
That's fair. Did you want to say anything about the admin law conference?
No, we attended the admin law conference virtually September 1 and 2. We go to that every year. That does. Well, the attorneys typically do. I don't have any particular update from this year.
It's helpful to us on rulemaking, on compliance with open meetings laws, all those sorts of non-forensic-y things that we are required to do as a government agency. That's all I have.
Okay. Next item are the complaints and disclosures.
Mr. Dr. Bernard, we have a little bit lighter agenda this time around. There's only 3 new disclosures and 3 new complaints that we can review. Our committee did not meet yesterday as we sometimes do, simply a couple of functions. Number 1 is the reduction in cases, and number 2, the fact that we're coming swift today. So our first item is item 22.35. It's a disclosure that came out of the Tarrant County Medical Examiner's office. Their lab seized drug section back in June. They had a package come in of evidence with 3 packages. One reportedly contained some Xanax, another hydrocodone, and the third methylcarbamol. And the packages were marked sealed when they showed up at the lab. As they reviewed the evidence, they came to find out that the envelope with the methylcarbamol was empty. They searched the reception area, and when I first saw that, I thought that might be their front part of the reception area. That's not a place to keep things. Where the evidence arrived, they searched the vault, they searched the drug chemistry lab, not to be found. They had done a number of corrective actions. They notified the submitting agency with re-emphasizing to them the importance of proper evidence packaging. They updated their chain of custody forms to include a section to document the evidence of packaging when it's actually sealed. They updated their evidence handling procedures to require verification of each step, transfers using a bin within the facility, and another verification step to check the bin after transfer. And then they implemented a tight ongoing monitoring plan to try to see if this doesn't happen again. And they also implemented some additional seal checks. I don't know what else they could have done. Staff had reviewed this carefully, as they so often do, and had made a recommendation to the commission, which I concur with, which is to take no further action in light of the corrective action. There's actually no root cause analysis. They didn't find it, but just the corrective action taken. If there aren't any comments or questions, I'm prepared to make that in the form of a motion to take no further action.
Any further comment? Is there a second?
Second?
All those in favor say aye.
Aye.
Opposed? Motion carries.
The second disclosure comes from Bodie Technology, their forensic DNA section. We had a analyst in the forensic biology section, Molly McGahey, that had actually falsified another analyst's signature on a forensic biology case report. She used a signature she obtained from a previously signed case report as a template, and she was seeking to expedite the review of the case. It was called on technical review. In July 29th of this year, she had submitted a draft forensic report containing both serology and DNA results for some internal technical review. The biologist in the lab, she took ownership of the results, but included both DNA and serology signed by the respective analyst in a common practice at Bodie. The review, however, noted the case file lacked both the self-review signature of the biologist and the second read worksheet. They notified McGahey and the biologist. The forensic biologist was surprised by the corrections. When they confronted Ms. McGahey, she explained she had in fact used a previous report for the signature as a template, and that her only intention was to expedite completion of the deadline they had within the lab. They placed her on administrative leave. She's been licensed with the commission since late 2018, had a blanket license from 2018 to 2020. So staff had reviewed this matter and recommended that we accepted this disclosure for an investigation and make a determination as to whether this would constitute professional misconduct. Any questions or comments or thoughts? If not, I will make that form of motion that the commission accept item 22.39, self-disclosure, for review of whether professional misconduct would exist. We need to form a committee.
We do. I apologize. I usually write that in the motions document, but I have thoughts about it.
Let's hear your thoughts.
I do
before
too.
you vote.
Well, there's always Dr. Copel and one of the lawyers, so Mr. Daniel or Mr. Parsons.
Rock, paper, scissors for this.
Actually, I don't know, both of them on it might be a great selection. Well, first of all, let's vote on.
Yes.
So you make a motion?
That we accept it for investigation.
Any further discussion? Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? And motion carries. So now formation of a committee. Dr. Cole,
Yes.
you,
I'll do it.
Mr. Parsons? Well,
I'll do it.
Sarah's gonna do it. All right, so we have a recommendation for a committee that Dr. Coble, Mr. Parsons, and Dr. Kerrigan. Do we need to vote on that, or we just?
Yeah.
Okay. Is there a motion to accept that?
So moved.
Second, okay. All those in favor?
Aye.
Opposed? Okay.
Which would bring us to our third disclosure. It comes from NMS Labs. It involves an interstate issue. They had disclosed to the commission an incident in their toxicology lab where they discovered that their services for Missouri tox cases were not meeting Missouri requirements for analyst certification. There are actually 9 clients covering over 280 cases. 2020, they had asked the quality director to research requirements in Missouri for sales purposes. The quality staff did not properly communicate to the sales division of NMS Labs that they already had several Missouri clients and had accepted cases from Missouri. The lab, however, did not realize this until the lab received subpoenas from NMS toxicology analysts to come testify in Missouri. They then found out that this oversight had affected about 280 cases with 9 clients. They set about to do a root cause analysis, which is fairly simple. The lab had worked DUI cases from Missouri without fulfilling their requirement for certification of analysts. The second issue was they continued to work DUI cases from Missouri prior to obtaining certification. NMS now presently provides a DUI toxicology service that will have to have a secondary research component to ensure they comply with all state certification. The sales department has contacted every customer impacted and directed them to contact the respective prosecutor's office and let them know of the situation and the disclosure required. And all existing customer accounts were placed on hold. So it was a certification / licensing issue. They had done everything they can to correct it. Staff had come to us and made a recommendation to take no further action in light of the corrective action and the fact the issues concern compliance. With another state being Missouri. Any questions or comments or thoughts?
I have one. I was just curious, was it a matter of they didn't apply for the license, or there was something they were missing? Just curious.
The requirements for the license was something that NMS couldn't comply with.
Okay.
So, but as quality, we researched it and notified sales, but we did not know that they were already working cases. So when that came to our attention, then we put the brakes on and said, no, we have to notify all these clients.
Yeah, I'm just curious what it was. So there's been a motion for no further action. Is there a second?
Second?
All right, all those in favor say aye.
Aye.
Opposed?
Which would bring us to our complaints. The first item is 22.37. I think Dr. Bernard was prepared to recuse on this being
I'll
false.
recuse myself.
Southwest Institute. It's okay, Dr. Brown, to preside over this matter. It's a complaint made by Otis Johnson, alleging a firearm analyst at Swifts failed to account for or eliminate the possibility of subclass characteristics were present in tool marks compared to her comparison of 2 bullets. The case was tried back in 2005. Ms. Thomas had testified that the bullet jacket fragment on State's Exhibit 36 and the bullet jacket in State's Exhibit 42 were fired on the same firearm, quote, to the exclusion of all of the firearms. When she was cross-examined, it was established that the comparison of projectiles was originally conducted by comparing them to test fires from a submitted .45 caliber weapon. The firearm in question was suppressed by the trial court because of a problem with the search warrant. There was fairly lengthy discussion of the lack of side-by-side comparison, and the analyst actually volunteered to conduct a side-by-side comparison without the firearm involved in court the next day. She did acknowledge there was some subjectivity in the comparison. She stated it was not possible for another trained examiner to reach a different conclusion when cross-examined. But then before the jury, she examined both projectiles, studied 36 and 42 for class characteristics. Before they're examined microscopically for individual characteristics. Based on her comparison with the characteristics, she testified they were fired from the same firearm to the exclusion of all others. She testified the 4 other firearm examiners verified and agreed with her conclusion. The lab had responded that the degree of certainty the analyst expressed when stating her opinion was professionally acceptable at the time of the trial and did not constitute professional negligence or misconduct because it was widely accepted in the discipline. They did acknowledge that the testimony with that degree of certainty is not presently authorized. That's frankly an evolution of the discipline as a whole. So there were basically a 3-tier part of the complaint. Staff had reviewed this carefully with regard to the first tier, which was the portion of the complaint alleging the analyst failed to account for or eliminate the possibility of subclass characteristics among the tool marks as being unsupported by the record. Staff had recommended, and I concur with, that we dismiss that portion of the complaint alleging her direct comparison of the firearm of the projectiles may have been influenced by her previous examination comparing projectiles to a particular firearm as speculation. The actually second and third part of the complaint is that we dismissed the portion of the complaint alleging the analyst expressed her opinion in terms that were then not scientifically supported, contingent on the laboratory issuing appropriate notification to the attorney's office. The commission previously noted labs involved in firearm and tool mark examination should not issue reports or provide testimony in court that could lead the end user to believe an association made with what we call absolute certainty. Any questions or comments or concerns? If not, I'm prepared to make a recommendation that we dismiss.
Mr. Daniel, we did receive, and it's in your materials, a letter that went from SWIFT to the district attorney's office, making clear that they reviewed everything substantively, and the testimony at the time was commonly accepted in the discipline, and that has evolved, and that was something that we encouraged them to do, and they were very eager and willing to do that. So that's, to me, closes the circle on the review.
Any other comments or questions? If not, I'll make a motion to dismiss the complaint. Second.
I'll second.
Motion and second. All in favor, say aye.
Aye.
Any opposed indicate by saying no. That motion will carry on. Turn this back over to Dr. Bernard.
Well, the next is number 5, or 22.38.
22.38 comes from actually a Brazos County matter. I think Dr. Parsons was going to accuse himself, wasn't he?
Mr. Parsons will recuse on that matter. I don't want to get called down for calling myself doctor too quickly.
No, you don't want
In
to
a room full of doctors.
Gotta be careful. And this was a complaint from Derek Conley, an allegation he possessed a CBD vape, which he claimed was purchased from a legitimate business entity, Fatty's Smoke Shop. Parsons, you don't hang around Fatty's Smoke Shop, do you?
I will confirm or deny that.
Probably.
Of course, it doesn't know where it is.
But that an Armstrong analysis had falsely reported the detection of the Delta-9 THC at a concentration of 4.35% plus or minus 0.36%, in addition to the detection of Delta-8 THC. And staff had requested that Dr. Carey maybe undertake the review of the lab work by Armstrong, and I was going to ask her if she could elaborate on that, please.
So there's nothing in the complaint that really addresses the challenge related to the forensic analysis itself. It's a vape liquid according to the records that were provided by Armstrong. It contains Delta-8 THC and relatively low concentration of the Delta 9, but it's above the legal threshold. So if there is a challenge related to the forensic analysis, Mr. Conley could have an independent test conducted, but really there's nothing in the complaint itself for us to act on. So my recommendation is a dismissal.
Can I ask you to make that form of a motion?
I'll make a motion to dismiss complaint 2238, Derek Conley, on the basis of the fact that there's nothing in the complaint that alleges negligence or misconduct pertaining to the forensic analysis.
Dr. Moore, I'll second that.
All right. Is there any further discussion? If not, all those in favor say aye.
Aye.
Opposed? Motion carries for dismissal.
Dr. Drake did weigh in late last night. She reviewed the record and concurs with Dr. Kerrigan's comments separately. She didn't speak with Dr. Kerrigan. She pointed out that in a market that has no oversight, regulatory oversight, it is sometimes easy for these products to come out that claim to be under the limit or within the threshold, or to not contain Delta 9, and then it turns out that they do. So that's something to be cautious of. But we had seen that previously in the validation work that Dr. Kerrigan did with the labs and reported to us on. So it is a difficult situation when there's no oversight with the producers who are bringing the stuff to market.
Is this just an ongoing problem in Brazos County, especially?
I don't think it's Brazos specific.
Maybe that explains why the football team's not playing quite as well. You may need to shut that place down.
Hey, that's a separate complaint.
If they would pay Jimbo Fisher more money, we would not have this problem.
I think my annual donations are being misdirected right now.
Which brings us to our last complaint. It's item 22.40. It comes from Ms. Nita Nix of DPS Austin, the breath alcohol section. She had a complaint with regard to some promotional practices from the breath alcohol lab. And there are some that may have a impact on some of the lab work, which is why it was sent to us. It's our understanding from staff that Inspector General DPS is presently reviewing this. Staff made a recommendation we table this pending completion of the review by the Inspector General. With that representation, I would make a motion at this time for any questions that we go ahead and table this pending their Inspector General review.
Is there a second?
Second.
All those in favor say aye. Opposed? All right.
Bernard, one quick housekeeping matter.
Okay.
Staff that in the interim from our July meeting until now had administratively, which they had authority to do under the previous commission action, dismissed 3 complaints, item 22.36, 22.42, and also 22.44. I think it's always good if we give our formal blessing and approval to that administrative action, dismissing those. So I'll make that formal motion.
Is there a second?
Second?
All those in favor say aye.
Aye.
Opposed? Okay. Thank you.
And that completes complaints disclosures.
All right, item number 7 is the discussion of the Crime Lab Accreditation Program.
To summarize accreditation-related events that happened this quarter, we had 8 accreditation-related events. 2 of those were new recognitions of accreditation for 2 different crime laboratories. We had 4 crime laboratories renew their accreditation. We issued 1 uncommon forensic analysis accreditation, and then we had 1 laboratory notify us of a suspension of not suspension of accreditation, but temporary suspension of accreditation pending a move, and then they were resumed services after the move. And that was it for accreditation statuses. As far as the rulemaking for CAP and SAMHSA and removing recognition of those accrediting bodies, that rule will take effect by November 16. so those laboratories will fall off. And there are only 5 of those left. We had one laboratory that voluntarily withdrew their accreditation effective immediately after we sent them the notice. So November 16 will be the earliest date that we don't recognize those 2 accreditation bodies. Did you want to go over the checklist?
Yeah, so this upcoming agenda item that we have on the Cologne matter will be the first time that we suggest items for the assessment checklist that we had talked about doing with the NIB. The Texas Association of Forensic Quality Managers has been actively engaged on their thoughts about how to best go about that, so we will be working closely with them. A lot of what they've asked for is as much clarity as we can possibly provide when we are asking them to measure their own operations against a recommendation that's in a report. The more clarity we can provide them, the more sure they can be that they're on the right track and that they don't end up with any surprises, during the accreditation assessment. So we're going to be working very closely with them. They are separate, though they work with the Texas Association of Crime Lab Directors. So it's 2 separate organizations, and I think we're really fortunate here in Texas to have everybody so organized and meeting and talking, because that's not necessarily true everywhere. So I'm glad that they are meeting regularly, and they're not shy about giving feedback to the commission, so that's good.
Further discussion or questions? All right, then let's move to item number 8, which is the update of the Licensing Advisory Committee.
Yesterday, the Licensing Advisory Committee met at noon, and we had quite a long meeting, mainly to discuss 2 areas of voluntary licensure, which we'll go over those charts next. But just to give you all a quick summary, we license now over 1,400 forensic analysts, and we've renewed over 200 forensic analysts licensed this quarter, and we have, I think, another 600 to go before December 31st this year. So Rodney has been extremely busy, and we have other staff also helping. Catherine's helped a lot. She does our background checks for us on every single licensee. And then our other newer staff member, Maggie, does a lot of help with the license application process as well. So we'll be very busy in the next few months. And I think Rodney told us yesterday that December is going to be our busiest month. I think we have over 200 applications to process. So we just want to thank everybody for their patience with us. Everyone's been super kind to us as we process their applications. We understand that Top Class is not the most intuitive system, so if there's any way that we can help you all staff as we process the applications, we're happy to help if you just email us directly, and we'll get to all the requests as fast as we can. And if anyone has any questions specifically that they want to address with me, I'm happy to answer those. On the voluntary licensure front, did you want to go over the charts?
Sure, we can. So there are 2 different charts that you have. One is for digital multimedia, and the other is for Friction Ridge. On DME, this was a group that we brought together that consisted of Troy Lawrence from Fort Worth PD, who was on the National Commission and is very involved in this discipline on various national committees and so forth. We had Damon O'Connell from Flashback Data. That's a private lab in Austin. They do a lot of work for law enforcement agencies, as well as Jennifer Land from Texas DPS, who is in charge of digital multimedia for that group. And then yesterday, we had 2 representatives from the CID part of DPS, so that's the Criminal Investigation Division. I don't even think that we fully appreciated how much digital multimedia evidence is processed outside of the DPS crime lab in the CID division. They were there and very much engaged in the conversation about what should be the voluntary license program. Originally, they were concerned about the formal education component of the other licensing programs because they get a fair number of people, as you might imagine, who are coming in with a law enforcement background or a military background. But then when they saw that we had incorporated these three, or the two paths, you know, a four-year degree, the non-law enforcement or military, but certification through one of these very rigorous certifying bodies, or the Path 3, which is law enforcement or military experience with training at, you know, by the military or the FBI or Secret Service or SAMS, IACIS. They felt comfortable that this will allow a pathway for people at DPS who aren't in the laboratory, because if you're doing DME in the laboratory, you have to have a four-year degree. They seemed very willing to, how shall I say, integrate this as part of their training requirements. They understand it's voluntary, but they see it as something that they do want to engage in and incorporate. And they did a beautiful job of explaining to us what those certifications entail, and these are quite extensive. So Troy Lawrence actually was the one who helped us with the piece of it that goes to laboratory quality and proficiency monitoring. And the reason we have that component is because, as you recall, these are not accredited disciplines, and that's by statute. So we can't require accreditation as a threshold for these disciplines if we wanted to without a legislative change. So the purpose of putting it together like this is to reflect some of those quality components, and we're primarily doing that through incorporating OSAC or similar standards documents that are in development. And that's how we ended up with this program. So it was very much fed by input from the community itself. At the end of the meeting yesterday, we asked the DPS representatives, you know, how do they feel about this chart in general? Do they think it's doable? They said, we feel great about everything but the statistics part, which is what everybody says. So but now they're just joining. I mean, even though the gentleman who had come actually had statistics from undergrad, but, you know, everybody gets scared by the statistics. So we told them, well, there's this great, easy course that Pepsi has put together that Dr.
Exactly.
has.
Not when they work with me. That's never scary.
So that's digital multimedia. On Friction Ridge, we had a lot of conversation. So when we put the Friction Ridge matrix together, we did that with the assistance of Jack Flanders from DPS Crime Lab, Henry Swaffer, who's the chair of the OSAC subcommittee on Friction Ridge and formerly with USACIL, or is he still with USACIL? I'm not sure if he's still there, but he was there for a very long time. And also with Ashley,
I think it's Rosivas
from El Paso Sheriff's Office. So we tried to get a diverse representation of people from varying levels of engagement in the national work and sizes of laboratories. Obviously, the Sheriff's Office is going to be probably less resourced than a big organization like DPS, or certainly the U.S. Army Crime Lab, where Henry comes from. So we talked with them, and they came up with a matrix that had as a threshold requirement certification for everyone, regardless of educational background and regardless of whether they're in an accredited laboratory or not. That was the proposal they put forward yesterday. During the LAC meeting yesterday, there were two representatives who are LAC members who are from accredited Friction Ridge sections. Sandy Parent, who sort of chairs the work of materials trace for all of DPS, and Deborah Smith from Fort Worth PD, whose subject matter expertise is in Friction Ridge. And they made the argument that for accredited labs, there is sufficient competency so that they should not also need to become certified. So that was the discussion yesterday, and the LAC forwarded to you a recommendation that the matrix be adopted, except they want to amend the requirement for accredited labs that IAI certification is not a mandatory threshold requirement. So it is for you to decide how you want to proceed. I would say the arguments in both directions are ones that you've probably all heard before on this. You know, people, there aren't very many certified IAI LP examiners in this state. There's 60 some, it's not even 70.
67.
67.
On the current site.
67. That's not very many. And so I think there was some concern that if you told people, like, you've got to get certified and then do this voluntary license, that would be difficult. It would be perceived as two barriers. And the other side of it, though, is that the IAI certification is one of the ones that's perceived as being fit for purpose. You know, we've had conversations in the past about ABC not being so great for DNA for a while because the exam was outdated and they were testing on technologies that were no longer in use. But Friction Ridge, I think, is a well-respected certification for that discipline. So it's really up to y'all how you want to proceed. The options are to adopt, I mean, you can make whatever revisions to this matrix you want, but the main debate was between should people from accredited labs also have to get the IAA certification in order to qualify for this voluntary credential that we're developing, or should that only apply to people who don't come from an accredited entity? And by accreditation, we mean either to 17020 or to 17025.
I have a question, is that do we think that in the next couple of years that this will move from voluntary to mandatory, like Friction Ridge will just become a mandatory?
Speak up.
Sorry, do we think that instead of voluntary in a couple of years that this will become mandatory for licensing for Friction Ridge analysis?
I have a hard time seeing the legislature require accreditation across all Friction Ridge providers throughout the state, because I don't even think we know how many we actually have. Now, could they, in theory, rework the law so that the licensing is required and the accreditation is not? Yes, they could do anything. But to date, they have not done that.
I support the idea that the examiners in an accredited lab should be exempt from the certification. I think that's a good modification.
For something that's voluntary.
Particularly for something that's voluntary.
The only other thing I would point out by the chart that wasn't mentioned is both supplemental to accredited labs and unaccredited. In this context that's different from our mandatory licenses is this quality component piece, where we're asking laboratories, regardless of your accreditation status, that you comply with all of these standards that come from the OSAC. These are especially from Friction Ridge that are on their way up to the OSAC registry, basically. If you look at the column that says employing laboratory or agency quality requirement. So even in an accredited lab setting, we're still asking for those quality components to be there. So there's that supplement too.
And for DME, it was Troy Lawrence who identified the ones that he thought were most important, and the folks in the group agreed. And then Henry Swafford pointed these that are footnoted here out for Friction Ridge. And the folks that were involved agreed, and everyone at the LAC agreed that these were minimum standards that need to be complied with. And I think the way we're going to arrange the rule is that we will maintain the list of standards on the website. It shouldn't change very frequently, but if we need to change it, that'll make it easier to change.
Quick question.
Go ahead.
Okay. What is the take of the three subject area experts about the IAI certification? Did you talk to them about this point? Did they express any opinion?
Yeah, I think they think it's generally a good certification, but it's, you know, people will say, well, I've met experienced examiners who are not certified, they just never went and got the certification, who are better than some who are certified. It's variable. I think the IAI certification is perceived as better tailored to the field than some of the other certification exams out there, but none of them are perfect, you know. But I think there was general support for certification. The question was just, if I have somebody who's in an accredited lab, I want to be able to tell them that we're all getting licensed, and I don't want the barrier to that, considering that we're already doing all the things for accreditation, to be that they have to go get the IAI certification. And they said the IAI certification absent accreditation makes sense because at least then you have a baseline level of competency.
Okay.
I have one question, so thanks for pointing out the standards issue. So now I put on my FSSB hat because I just want to know, these three that are listed on the first page, can we add the document names to these? We've got some titles, but they're not on the registry.
They are not.
They're at
So we're-
SDO.
They're
Among the top three at least are at the SDO.
So these are being worked on by
Yes.
by ASB?
Yes.
But they are on the subcommittee's website, and Henry said as far as he's concerned, they are ready for labs
Okay.
and entities to comply with them.
Got it. So they're pre-SDO?
Yeah.
So they're not really yet standards?
I think there's some debate about how the community should perceive some of these documents. And he was insistent and comfortable, I think, with the notion that those subcommittee documents are good standards that should be followed and adopted by the community, even though they're not yet in the registry. And if you go to you can see that they're all available they're all in Friction Ridge subcommittee, but if you then go to the registry, they haven't all crossed over through the process to get there yet.
If you look, the last one, that does say a plan for implementing these, though.
That's
One,
just for
two,
the
and
best
three.
practice.
Yeah, for the best practices ones. So the only ones that we're asking labs to demonstrate compliance with are 1, 2, and 3. And the second two are have a plan for implementing them within a reasonable time frame.
We're also asking for compliance with the Friction Ridge Subcommittee's standard for proficiency testing and Friction Ridge examination when it comes to the PT, or monitoring, proficiency monitoring.
I think it's good. I think we should just clarify the document and include the title. I'm looking at it now, it says OSAC proposed standard in the name, but it doesn't have it simply doesn't have the numbering system that we're using now because it predates the process. So now it makes more sense. So,
We'll clarify.
yeah.
All right, so we're going to, any further discussion? All right, first I need a motion whether to accept the proposal for voluntary licensure requirements in digital multimedia as proposed.
So moved.
Second.
All those in favor?
Aye.
Opposed? That motion carries. Now, the second would be a motion to accept the voluntary licensure requirements in Friction Ridge, or is there any modification needed with that?
The modification suggested by the LAC is to not require certification for laboratories that are accredited to 17020 or 025.
Oh, no, the IAI, right?
Yes.
All right, so is there a motion to accept as proposed?
That modification.
With that
so moved.
Which is,
So moved.
all right,
Second.
second. All those in favor say aye.
Aye.
Opposed? Both motions carried.
Okay.
Do you want to do
See.
something exemption next?
Um,
Let's talk with the exam. So in your materials, we talked about this last time, but I just put the final copy of our psychometrician's, refers to it as the standard setting report. And this is the final copy of the report that shows what the cut scores are for the 3 different versions of our exams. And if you all recall, we decided to set a minimum number of questions you have to get right in each domain. And we've established that number for the technician's exam, the modified exam, the exam that you take when you go transition from a technician to a full analyst, and then of course for our regular exam. And those are all described in that standard setting report. And we've launched our general forensic analyst licensing exam too, so folks can register for that. The deadline to take the first exam that we have is January 1, 2023. That's our cutoff date, and we've notified labs, we've posted on our website that that's the final date we'll be offering that test. So if anybody has any questions about that, let me know. Posted all the information about registration and accessing the study materials. Everything's available now for that. So we're happy to close that chapter in developing the exam because it was a big undertaking, and I like to think it's a really great exam. I think that our subject matter experts did a really good job in developing the exam with feedback from last year's exam. I think the next topic would probably be
Yeah,
the
so we have this
NIBIN.
perpetual issue with NIBIN suitability, which is that there are a number of law enforcement agencies across the state who have NIBIN that was installed usually by ATF, and they engage in suitability determinations, which typically entails assessing a set of test fires or cartridge cases for NIBIN entry. And sometimes they test fire in order to be able to do the NIBIN entry. The problem is that those things are happening in entities that are not accredited or licensed. But there's no way for the laboratories to absorb all that NIBIN entry work. And I think what we would like to do is put forward a rule exemption that is narrowly tailored to that component of the work, but is clear that it only is limited to the test fires for NIBIN entry and not for comparison or for determination of functionality. Those things should be sent to the laboratory. We talked about it for a very long time yesterday. We do have a firearms expert on the panel, Donna Udaley, and Bexar County was sharing their experience with San Antonio PD. And the idea is essentially that the labs cannot do the NIBIN upload, but they want to have there be a pretty clear line in the sand where you can go up to this point with the NIBIN suitability, and after that you need to send the stuff to us. So they think this will help provide some clarity and guidance. We do, Lee, typically gets requests from some of these law enforcement agencies asking, like, we're not accredited, we have this ATF NIBIN system,
Should we be
should we
accredited?
be? And the answer is that if they're only doing NIBIN entry, we think it's appropriate to carve out the exemption as long as we're clear about where that line is between NIBIN suitability and analytical work.
We uploaded this language to your Govinda last night because we discussed it at the licensing meeting yesterday. I don't know if you all have your Govinda up and want to look at the language. If not, we can probably read it to you too.
The exemption is for determination of NIBIN suitability limited to triaging or grouping multiple items of evidence for NIBIN entry and assessing a set of test fires for purposes of NIBIN entry. The suitability assessment may include test firing, but only if no physical modification is made to the firearm other than what occurs during the act of test firing the weapon, and subject to the condition that the test fire is for NIBIN suitability only and may not be used for comparison purposes or for determination of functionality. That will go out for public comment. So it's possible it will get revised, but that's the draft. Well, we need to accept it.
Okay. All right, so hearing that, is there a motion to accept that exception or that delineation as read?
So moved.
Is there a second?
Second.
All those in favor say aye. Opposed? Motion carries.
And then the final issue under licensing is that NMS made a request for their de minimis licensees to be able to do an in-house training in lieu of the 2-hour-long training that Robert and I developed on Michael Morton and compliance with the Code of Professional Responsibility. Not for their interpreting analysts, only for the ones who are doing less than 10% or less of Texas casework. The rationale for it is that they have a lot of oversight from various states and also from various elements of the work that they do, and their attorney, MJ Menendez, took a look at our training and then tried to develop something that's streamlined for those analysts who are essentially, if they were ever to be called, would be more like chain of custody witnesses, is sort of how it was framed for us. It is definitely something that I think there's no question that our existing training, the 2-hour-long one, is more detailed. It's sort of tortuously detailed in terms of the number of explanations that Robert and I give of forensic science examples. But it was sort of designed that way so that nobody could misunderstand the point. I know that many of you have watched that. I know Dr. Kerrigan has for sure. So the question before you is whether or not it's okay just for the de minimis licensee holders at NMS to be trained under their slide deck, which is in your materials, which does cover Morton and it does cover Brady and it does have Texas examples in the audio. It's just not at the level of depth that we do in the training that Robert and I developed. They did commit to watching the new training that we developed every 2 years and revising their own training to reflect it. So it's really a question for y'all to.
And just to be clear, their de minimis analysts have to watch it every 2 years as continuing education, so they're asking that they can watch their video every 2 years instead of, they have to watch it when they apply, and then every 2 years.
Well, it is an annual training, right? At least.
It's annual,
Yes.
yes, it's,
Yeah.
yes.
How long is the training that you and Robert did?
2 hours.
How long is the training that NMS did?
About an hour.
We're talking about an hour extra.
Well, it would
No,
be.
well,
Well,
would
no,
be-
she gives it every year.
Ours is, we have, for all of our other accreditations, we have to do the ethics training. That we've incorporated all of the pieces and parts for all of the accreditation bodies in ours. If you choose not to just allow hours, it would be a 3 hour, so your 2 hours plus hours.
So I have a general question about this, because if we approve this request, are we planning to approve other requests from other labs to provide alternative training other than the training that is currently required? And for other domains? I mean, where does this go, right?
I think we would have to consider it, certainly if we approve this. We would have to, anytime someone brought it to us, we'd have to review their slide deck and see, and review whatever it is they were proposing.
I think it's a reasonable request, but my concern is we start down a slippery slope with future requests without parameters or structure. It's not a dangerous precedent, but you are setting a precedent.
Is there some training that you could do that would be less onerous for them to watch, that would satisfy what you want them to know? I mean, is there something wrong with the training that they don't like, that's too long or it's too detailed for what they need?
I think it's just that it's a lot of examples and it's very detailed, and that, that it's probably more than maybe they need, but we just feel very strongly about that particular
And
subject.
that needs to be in place for the people who are not de minimis.
They are,
So you would want to
yeah.
have two different ones, like one for the de minimis and one for everybody else.
I mean, I suppose we could do something like that. It would require Robert and I to, we already, it's quite a haul to update it every 2 years, because Robert, is monitoring case law to see what examples come out, and then we've got to put the slide deck together, then we have to send it to Sam, we got to do the audio. It's like, it's a whole,
Yeah.
you guys know who are faculty, that creating these things is already pretty arduous.
Yeah, but even if you do that and you do a short version of the current course, I think that the core question is to which extent you draw the line when you can say you can watch the 1 hour instead of the 2 hours. That's, I think, is more of the problem of the precedent that we are about to create, because here there is a rationale, because they have only up to 10% or whatever the criteria were. Is that a valid reason to allow that? Because that's, I think, is the criterion for the slippery slope potential problem that might be. Not even the 2 hours and 1 hour, because also another question would be to ask how impactful would be to watch 3 hours instead of 2. But I don't know, I think that where we should really ask is when, to which extent do we concede? Because is that worth it for you to really do a short version in the first place based on that? I don't know, just a thought.
I think the other challenge is that the commission's already expending quite a lot of effort developing the training so that the labs don't have to come up with their own training to meet the requirements. And when we get a request like this, there's a responsibility on the staff to review and compare the curriculum, and do we have the bandwidth to do that for any lab that might make the request? Because if we approve this, even though it may be really good training, we're going to have to review alternative training and curricula to determine equivalency for any other lab that makes the request. So that's my concern. I'm not sure that the staff have the bandwidth to do that.
I think one of the things about the depth that we go into for the training is that in a lot of the work that we do at the commission, what we see is that it's never the laboratory issue itself, or rarely is it the issue, that the error or the problem in the lab. It's sort of reaction to the problem is where we see challenges. And, one of the things that we consider as lawyers is, okay, what training have they had on this? And you're going to see that in the Cologne report that we're about to discuss. And we went into all this work to figure out, like, what did they hear and what can we assume that they knew or should have known based on the information we're getting from the laboratories and what we have put out there. So it is a little bit harder, I think, later on, if we ever had to assess conduct, to do it if we if we don't have everybody watching the same thing. I get the need for the request. The efficiency ask is basically like, why do we have to have people off the bench who are probably never going to set foot in the state of Texas, to watch these videos for 3 hours. I definitely get the practicality of it. And we would review requests as they came in and make recommendations about whether we think that it's sufficiently thorough. MJ, we know her. She's an attorney who was at DOJ. She knows the law. So that's not a question in my mind. It is the question of, like, okay, now is everybody else going to ask us for the same thing? That is a real issue that may happen.
And
I don't know.
potentially not just for other labs, but for other domains as well,
Right.
right? So there's 7 domains, and so to me, it's, as you said, it's not to do with the quality of the training that's been provided, but it's more the having to make those exceptions for potentially any lab and any domain.
Well, the domain piece, so this is just for CE. It's not the material for the exam. I mean, that is a separate issue. This is for every 2 years, they have to take 32 hours worth of CE, half of which needs to be in the discipline, and everyone, de minimis or regular licensee, has to take Michael Martin and professional responsibility. Now, it was NMS, if you all recall, who wanted those de minimis licenses originally, when we first created the program. And I do remember a conversation with Rob Middleberg where he said, we'll do the Martin stuff, we'll do the Brady training. Can we just have something that is less onerous than the full license for those folks who are doing de minimis casework, essentially? At first we had the blanket license, then we went to the de minimis program. Now I just think they're looking at it and saying this is a lot of time for something that we can cover more quickly in a more efficient training. I mean,
Yeah, when you think about, if you're a training manager for a laboratory like NMS and you service so many different states, you're going to show a 2-hour video for tailored to Texas laboratories. They may never touch a Texas case, right? Your employee manager, you're going to give your 2-hour training, then you're going to give a Nevada 2-hour training. How much of that is this employee really going to retain? I mean, you would want to create your own training that encompasses everything into a condensed 3-hour training that they might actually retain some of the information from. So I can totally get why you would want to put it into something that they might get something out of, rather than saying, here's all the material, go home and watch 5 hours of material, and then you can work any case in the laboratory. Because how much are they actually going to, if we're going to hold them responsible for understanding all the Texas material, like you say, I mean, they watched 5 different videos from 5 different states. How can we really say that they understood everything in the 5 videos that they watched?
there is
That long.
there is one difference between our training and what they're proposing, if I'm understanding right. There's no quiz questions embedded in there, right? Or are there?
There are some questions, some scenarios, and we give them options of what would you choose, and then we discuss it afterwards, but it's not really a quiz.
Yeah.
I mean, we
so,
do
yeah,
give them scenarios of, in this situation, what would you do, and then they have to choose their answer.
So, I mean, we do have the quizzes embedded, but it sounds like they're doing something similar.
The basis for the request is to make it more efficient for NMS and save the 2 hours per exam.
All right, so we need to move forward. Is there a motion to accept the proposal to reduce the training for NMS for a select group of people? Not hearing a motion? Then there is no motion.
So we will let them know.
All right. Item number 9, update from the investigative panel.
Did you want to take a quick break?
I was going to step out, but I mean, we can move forward if you want. Let's take a 5-minute break.
Okay.
Just politely saying. That's kind of the message I get.
All right, the next item is number 9, which is an update from the investigative panel regarding 22.17 Fort Worth Police Department Crime Laboratory
So, as you may recall, we had that major proficiency testing nonconformity, which got folded into a reaccreditation assessment that NAB did. They sent a full team out and re-observed that entire assessment. And they had 9 nonconformities and 2 conforming with comments. They have until October 24th for NAB to decide whether or not the action they've taken is sufficient to address the concerns that were raised. They've already, by they I mean ANAB, has already approved the course that they were setting on to do the corrections. Now, whether it's been done sufficiently will be decided within the next couple of weeks, so we will have an update at the January meeting on Forward PD. They have had a major change in quality management, and that has definitely expedited resolution without a doubt. So I think we'll be able to get a good update to the commission in January.
All right, item number 10.
This is the PowerPoint. So I have a PowerPoint. This is a report that we've drafted on a matter involving forensic biology screening. I feel like I should stand, but I'm not sure if there's actually space. I'll just sit, I guess. Okay, so can you put it into the slideshow, please? Okay, so it's disclosure 2218, and it was a disclosure that came in from the Houston Forensic Science Center, and then was followed up by 2 QIs, quality incidents, from Texas DPS. And the case is State of Texas versus Cologne. So we received a self-disclosure from the Houston lab on April 7th of 2022, and it concerned the testimony of DNA analyst Stephen Adam Benson in the capital murder trial of Joseph Cologne. He was tried in Jefferson County in 2017. At the time, the analyst was employed at DPS, so when the forensic biology screening was done, he was at DPS in Houston, but when he testified, he had moved on and became a DNA analyst at HFSC. The facts of the criminal case are that Cologne was convicted of capital murder. There were 2 women murdered, a mother and daughter, in their home or on the threshold of the doorway and inside the home. Cologne was sentenced to death, and it was a case where the assailant was wearing a mask, and so identity was a question. The DNA-related case facts, we don't go over other case facts, but the ones that are relevant to what we're talking about is that investigators found a dark knit glove inside the home and a blue towel outside. DPS reported that Cologne could not be excluded as a contributor to the profiles found on the glove and the towel. So this slide goes over trial testimony that was given by the analyst. He performed forensic biology screening in October and November of 2013. And then 4 years later, he appeared at trial. He did not bring a copy of his lab report and had not reviewed the case record. And interestingly, for the lawyers in the room, during the trial phase, none of the lawyers requested the case file. So here is an example of some of the testimony that was offered. The prosecutor asked, have you had an opportunity to review a report? The answer was, I have not seen my report in a while. And she says, gosh, so you're doing this completely off memory. Okay, if I allow you to take a look at your report, would that refresh your memory? So she handed him a copy of his report that was her copy that even had her notes on it. So this is key testimony regarding the condition of the evidence, which is what ends up being the crux of the court's concerns, and we'll get into those. But the testimony was, question, when you received all of the items in this case, sorry, that's a typo, did they come to you in a sealed container? Answer, I believe so. If it were not sealed, I would have noted it in my laboratory notes. Question, and had there been something awry with it, had it not been sealed or something like that, you would have noted that, but you did not in this case. And the answer was Houston DPS has an evidence receiving department, so before any analyst sees the evidence, they verify it's been shipped correctly and in a proper sealed state, or they don't admit it. And then she asks, and for purposes of the record, the same with the styrofoam cooler, which was inside the cardboard box. Same principles apply to that piece of evidence. And she says, the analyst's answer is yes. So then they go on to talk about another component of the case, which is the amount of time that it took him to do the screening work. And the question is, give the jury some idea of the amount of time it would take to do the work. And he says, I'm not sure the amount of time. I have to reference the case file with my lab notes, but looking at the amount of evidence, I'm thinking it would have taken me several days. Question, okay, there's some notes somewhere then that would show what actual work you did on what actual day, I would guess, correct? Answer, yes, it would be in our case, but I'm no longer an employee of the state, so I do not have access to that information, which ends up being a critical item as we go forward. So Cologne is convicted, sentenced to death. The conviction's affirmed on direct appeal by the CCA, and then the Office of Capital and Forensic Writs was appointed by the trial court to investigate and prepare a writ on behalf of Mr. Cologne. And you all may know this, but OCFW is sort of the judicial, it's a part of the judicial branch, and it is a public defender for the state for capital cases. So OCFW did get the whole case record when they were investigating it. They subpoenaed it, DPS provided it, and what they came across was the following: 47 pages of bench notes regarding the packaging conditioning, excuse me, the description, testing, and collection. One of the notes describes the styrofoam cooler that contained the key evidence that was pulled from the scene, and the note says, despite stickers indicating to refrigerate on arrival, I pulled this item from a regular shelf in the vault. The packs were room temperature. The FedEx envelope is damp and soggy. There's a foul-smelling water or liquid at the bottom of the cooler. So this was of great interest to the lawyers for Mr. Cologne. As you might imagine, the bench note also said, I will inquire as to why the storage instructions clearly indicated on the outside of the item were ignored. The liquid will be soaked up with towels, discarded. There was no quality incident initiated at the time. No photos were taken of the cooler, of the FedEx envelope, or of the manila envelopes containing the items themselves, which were inside the FedEx envelope. Subsequently, OCFW did take some photos that ended up in the record, but at the time, DPS did not have photos. So post-conviction, there were two affidavits that were executed, one by TL Andrew McWhorter from Houston DPS, and another one by the analyst himself. We will say that when we interviewed Mr. Vinson, he made it clear that when he met with the DA's office, they told him what Mr. McWhorter's position was on a couple of things. Number one being that the storage was compliant with DPS policy. DPS has since amended and clarified that no, it was not. And also that it did not impact the results in the sense that there was degradation or contamination sufficient to be concerned about. That was also corrected by DPS in a later QI. So at the deposition, this is sort of a summary of the testimony that was offered. He said his trial testimony was accurate and complete. He maintained no DPS policies were violated, and the quality system requirements were conforming, essentially. The actions were conforming with the quality system. He basically said there was no potential for contamination, which is not something that I think people will say conclusively, period. But he said that the facts here did not present a potential for contamination, and that degradation would result in loss, which is true but incomplete. So the observations we have in this report are that Mr. Vincent was negligent when he appeared at trial unprepared. He came without a copy of the report, didn't look at the case record. Now, there is no express rule that says you have to review your report or case record before you testify, but the guiding principles that have been in place before we existed, before the commission was here, before there was a licensing program, set expectations about presenting accurate and complete information and testimony. And in fact, those guiding principles were a big part of how all the other codes of conduct have been created since then. HFSC had conduct expectations in place at the time. And so I don't know how one could ever comply with these expectations if you show up without your lab report and without having looked at the record at all. We also say he was negligent in failing to acknowledge that he hadn't reviewed the bench notes when he was asked. So the trial testimony was incomplete and misleading. It is true that the prosecutor offered a compound question that was not ideally asked, but he agreed that the same principle applied to the cooler that applied to a white box containing the evidence, which is that had something been awry with it, he would have documented it in his case notes, but he did not in this case. The truth of it is that because he hadn't reviewed anything, he didn't remember the condition of the evidence. So this issue with the cooler and the pooling of the liquid was not in his mind because he hadn't looked at anything. And so the finding here is that he had an obligation to answer truthfully that he did not know and therefore could not give an answer because he hadn't reviewed the file at all. He testified he didn't have access to the information. That was factually incorrect because, of course, DPS would have given him access to the record, and he does admit that later in his post-conviction deposition. We have a misconduct finding because later on, when asked under oath about the impact of his failure to prepare, he refused to acknowledge it. He had been trained multiple times. Since between 2017 and the 2020 deposition he gave, a lot had happened in the forensic community, including the introduction of the licensing program, the Code of Professional Responsibility, lots of training on testimony. HFSC has given us records from April, which is pre-Kreiner. You remember the Kreiner case that we reported on? So they offered training multiple months that went over all of these issues in a parallel case that is shockingly similar in many respects to this one. We recognize in the report that it is complex to assess testimony because it's the adversarial system, and making a mistake under fire in that context is anyone could understand how that could happen, but that he failed to follow the standard of practice that an analyst would have followed when he would not even acknowledge a very easy question that, you know, if you had reviewed your case record here, couldn't the jury have been given a more complete picture? And he refused to even concede that point. So here are some excerpts from the training that Mr. Vinson received on the Kreiner report, which you all, I'm sure, remember. I know Mike Coble definitely remembers it because he helped prepare that report. So it's not the mistake that creates the problem, it's the reaction to the mistake. That was Dr. Stout. If you cannot answer a question accurately, don't answer the question. That was Robin Gidry, the DNA TL. The analyst in Kreiner did not review the full case record before testifying, which resulted in her being unprepared. You need to be familiar with your case record before you go testify, all things that the TL stated. This is the general counsel for HFSC, Akila Mann. She said, once you know something's wrong and you didn't prepare, you need to stop the show, essentially. And by the show, she means at trial, you need to say, I cannot answer that question. You can control how you prepare. You need to look at the case record and anticipate what might be an issue. And then directly quotes from the Kreiner report, shifting of blame and deflecting responsibility is troubling. So Vincent gave his deposition testimony a year after he received all this training on the Kreiner case, but yet still attempted to justify his lack of preparation by citing his practice of testifying from his report and only referencing bench notes if instructed to do so. He said, I do not testify from those notes. Well, that may be true, but that completely evades what is the crux of the question, which is you may not testify from them, but you need to look at them before you walk in if you expect to be prepared. We have 3 professional responsibility violations cited in the report as well. We state that he was negligent when he insisted there was no possibility of contamination due to storage conditions and downplayed potential degradation impact. Now, DPS came back around and clarified a lot of this information in their quality incident in September, because some of this was originally in Andrew McWhorter's affidavit, but they have since amended it. So it's not reasonable for an analyst or a laboratory to assert that DPS handled the glove, towel, and swabs in a manner that would prevent degradation and contamination. And the point that Dr. Bedoli made before he retired and left the commission is that that created essentially a microclimate by having that water melt, or the liquid melted in the bottom, right? So you're having, he described it as a mini Florida you've made in your cooler by allowing that stuff to sit there. So that's a problem, and you cannot say that DPS was compliant with the NIST Biological Evidence Preservation Handbook, because they do say that clothing can be stored at room temperature, but they don't say that in the context of a cooler that's got liquid sitting in the bottom. Also, we need to remind ourselves that a reagent blank contamination check in itself is not going to be sufficient to detect carryover if that's a concern. There's this implied information embedded in the testimony that degradation can be assumed to benefit the defendant. That may be true in many cases, and it's reasonable to say why that may be true in many cases, but it's not going to be true if you lose the foreign minor contributor, and that is an alternative suspect, right? Degradation doesn't impact the assessment of number of contributors. That's not always true either. So we need to be careful about the conclusiveness of statements like these. So we also go through what accurate and candid statements would include, and these were all included in DPS's 2 QIs that they did following the HFSC disclosure. We talk about the fact that similarly there are code violations here. It's not scientifically supportable to state conclusively some of the things that were stated because they exceed the limits of science and existing technology. We do say that both Vincent and DPS itself as an agency should have initiated a QI when the conditions were discovered in 2013. That's something that DPS references in its September QI. The failure to initiate it led to some of these downstream consequences in a way, because if they had initiated it, it would have been noted in the formal report, but that was never done. And then we talk about disciplinary action for the licensee, outlining the factors that are considered as, the seriousness of the event, and this was very serious. I mean, there are few more serious criminal case facts than the ones that are at issue here. And the impact of the testimony and the subsequent evasiveness in post-trial proceedings are what led the court to conclude that the defendant's constitutional rights were violated by this entire train of events. He was, when we interviewed the analyst, he was cooperative and self-reflective. By the time he got to the interview with us, he understood the Brady implications. He has no conduct history. He did receive information from the DA's office that DPS took a certain position, and he was consistent with that in his testimony. DPS could have been more proactive by forwarding the information to him, knowing he was set to testify. So we talk about recommendations regarding people who leave the lab but may have to come back. His license expires December 5th, so the proposed penalty is suspension for 60 days because the license will expire. Right now, his license is undesignated because he has departed the Houston lab. And then if he were to seek renewal, which a threshold condition for applying is that you have to be employed as an analyst in an accredited lab. If so, he would need to be hired by another lab and then apply, and we may impose conditions on licensure at that time. So one thing that became really clear to us in the course of this process is that Michael Martin Act implementation is really challenging for labs. When you get right down to it, the reason is because discovery is request-driven, but the law does not require the defense to request exculpatory, impeachment, or mitigating evidence. It has to, the state has a duty to disclose it. So the laboratory may be in possession of information that the court or the fact finder would consider to be exculpatory, impeachment, or mitigating, and the lab may not even realize it because the lab does not have access to the various theories of the case that are being put forward. The court is very clear on the importance of the lab not substituting its opinion in this area when, in this quote, where the judge says, Mr. Vinson and Mr. McWhorter's opinion did not definitively dispel the issue raised by the bench note. In other words, whether it mattered. The issues raised should have been resolved by the jury in its role as the fact finder. So the message is that analysts and labs cannot substitute their judgment of what may be significant for rating purposes. But in defense of the lab, you may not even know a lot of the time whether what you have in your possession would be considered in this light because you don't know the theories of the case. So our recommendations include several fact-specific recommendations as to the Cologne case. The ones that I think are worth discussing here is this is the first report where we do have these accreditation checklist items. And one is that analysts should prepare adequately for testimony, and lab policies need to clarify what that means by discipline. And DPS did that post-Kreiner. They have a very clear set of expectations for DNA analysts, and right now they're looking to see whether they have equal clarity in other disciplines. So what we're asking is that labs evaluate this question, and then if they need to, they should revise their SOPs to make it clear what the expectation is so there's no ambiguity. We also have a request that labs consider expectations for departing employees and whether those are stated clearly. And also, how do you know whether once your person has left the lab, they're still competent to offer testimony? Maybe a lot of time has passed. So there should be an understanding of how you're going to approach those situations. And that labs should adopt policies facilitating a new employee's need to prepare and testify for something that they did for a former employee. And I know it's hard to give people time to do that. So one of the things we're suggesting is that TAPLID work on this question about whether there could be some understanding developed between the Texas labs that says, if our people leave and go to your lab, we all have the same understanding about what time and resources will be afforded to people as they move to other labs so that they can prepare appropriately for trial. DPS has put an exceptional item in its LAR requesting a statewide laboratory portal. And what this will be is an API that links all of the LIMS systems to a central website where if you are a prosecutor or defense lawyer of record, and otherwise you're authorized to access the information, you sign in and you have essentially access to the LIMS. And so the records are pushed out all the way to the defense. If the defense does not review them, then it's a question of an ineffective assistance of counsel, but it's not a question of whether the laboratory sat on information. It will hopefully prompt courts to grant requests for experts to help lawyers evaluate those records when they're given access to them. Of course, this is a request that's gone into the legislature. We don't know if it'll be approved, but it is agnostic as to the LIMS system that the lab uses. So if you use Justice Tracks, you'll be able to access this, and if you use a different system, you will as well. That's the way it was scoped out. And I don't recall exactly how much they're requesting, but I think it's in the $5 million range for implementation. And then we are going to host an online training to discuss the contents of this report, as well as what the trial court said about Brady and Michael Morton Act-related findings as they apply to forensic labs. And CFE will be provided for that. So this PowerPoint is designed to summarize what's contained in the 40-page report that is before you. Does anybody have questions about any of it? Any input from the lab? No? Covered it all.
I don't have any questions, but I was on the report, but something else that is not quite on all fours, but may need to be addressed in the future, is that many times from a prosecutor perspective, we have analysts, when we talk about agreements between labs, we have analysts who leave lab 1, go to lab 2, and then so they've done the work at lab 1, they go to lab 2, but then there are exorbitant fees that are charged to prosecutors' offices at that one time, and I know that forces prosecutors sometimes to have to complete cases because they do not have the funds to pay the person who essentially is now putting themselves out to be an expert because they did this at, say they're a DPS, but then they go to a lab over here. There needs to be some sort of discussion as to some sort of agreements as to how this thing works, because the work is done here, they are now over here, and now they're extremely exorbitant fees that are being placed on DA's offices at that one time in order to have case work to come to court on case where they did essentially at another lab for no cost. So I'm sorry, I'm pointing this way. I wasn't pointing on this.
It kind of depends on what you mean by exorbitant, but there's also, you can't give away taxpayer services free. The law doesn't allow that either, so there has to be some means of defining how that's going to be handled.
It is.
That's been a problem.
It's not different, but it's different for every person because there is no foreseeability or anything like that, and it's per examiner. And so it is, I mean, we've had to get to the point of basically having to have two choices. If it's a case that's a non-death case, and it's, look, we're subpoenaing you for the casework. If you would like to not look at your file and essentially commit misconduct, then go ahead. But we shouldn't have to be doing that with forensic scientists. We just shouldn't be in that position. So some sort of discussion should be out here going forward.
Well, I agree with that, but I also agree that if someone is at another place and they're unable to work because they're pulled away for 3 days, then the laboratory where they're now working is also being punished for that. So there has to be something that is agreed upon.
And I think the lab that they're at should be the person that's essentially making that call as opposed to just the individual person.
Well, no, that's a different issue, yeah. I mean, that's
So,
why we have our attorneys.
I think that would be something that we're encouraging the TACA to talk about, is whether they can establish some expectations for how all of it is handled. And I think it's the challenges that I heard when we talked about this previously. I think especially for the county labs, it's tricky because if you're on Dallas County time, you should be doing Dallas cases, and so accounting for all that, it's difficult. But I think what you're saying is
it's
a
above
good
and
point.
beyond. Yeah, it's
Yeah.
above and
Well,
beyond.
Yeah.
that depends. I mean, if there's like, it's supposed to be cost recovery for their salary versus there's money being made. There's two different numbers.
Yeah.
Again, the problem we run into is you can't give away taxpayer services. And if they're on county time, going to testify somewhere else, well then the taxpayers are getting nothing.
I think absolutely. And so I think that the discussion should be between the MOU essentially. What would be the recouping taxpayer
Yep.
services as opposed to $4,000 and $5,000 for testimony?
Oh, I mean, when they're on Dallas County time, Dallas County has a set charges that they bill.
Yes.
That's been approved by Commissioners Court, and we still run into battles sometimes about that. But yeah, it's an issue that needs a resolution, one way or the other. Okay, no further discussion. Is there a motion to adopt the final report?
So moved.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. Next is an update on Expert Talks.
Expert Talks has appealed the commission's report and findings in the complaint that was filed in 20.55. So we are working with the Attorney General's office on that process, and Expert Talks is represented by a firm here in Dallas who has asked to meet with us on the 17th of October, so we'll be doing that, and we will update you as we move forward. It will be appealed to the SOA.
Okay. Item number 12 is an update regarding the complaint 21.27, University of Colorado National Innocence Project on behalf of Nanan Williams.
So we are waiting for NIST to issue the foundational scientific literature review on firearms. Dr. Butler at NIST says that it should be done, I think, late fall, but by the end of the year, so we should have an update before January.
All right. Next is item number 13, update from investigative panel for 21.72 Brazoria County Crime Lab.
We were planning to have Dr. Mark LeBeau work on this project. He reached out to me and said that he thinks the FBI will allow him to do it directly, not as a consultant. So we are going to arrange a meeting with Derek Sanders at Brazoria County to see how we can help them move forward and make sure they're on the right footing before they resume casework. So we'll have an update in January on that.
All right. Next is item number 14, is update on investigative panel complaint 22.16 Joseph Webster.
We have retained Glenn Langenberg to advise us on that report, which we think will be very helpful. He's already provided a really nice sort of evolution of the discipline discussion for us. Ron Smith, we were going to be interviewing them. Mr. Smith had a medical emergency, a very significant one, so he asked for more time to respond to some questions that Robert had posed, so we expect that we will have those by the next meeting, and maybe even a report ready, hopefully.
Okay. Next item, number 15, is discussion of the development, training, and education projects.
So we do have Mark Smith with us here, so I wanted to make sure you all knew that Mark has joined us, and he was at Cale in Plano before, so this was a pretty quick trip for him. So welcome, Mark. I know some of you already know him from having lectured at Cale when he was the chief executive there. Mark has been moving the ball forward and is very patient with me on a lot of these forensic development, training, and education projects. We have a DNA training for lawyers outline that Mark worked on that is looking really good. It involves a case-based scenario, and it's 2 or 2.5 days, we're not sure yet, worth of training. Judge Hervey is looking at that outline right now, and then we will circulate it among the commission. But we think it's going to be a really great training once we're able to launch it. We've been working diligently with a number of DNA labs to talk about evaluation of profiles for exclusionary purposes, and that's something that came out of the James Smiley report. So we will be moving forward a meeting on that where I think UNT is going to host. So that should happen hopefully by the end of the year. And we will be doing from now on Zoom calls on every report that we issue because we have those accreditation checklist items and we want people to be able to ask questions about the recommendations and compliance with recommendations, so we will be offering those. And then I wanted to give Dr. Kerrigan a chance to talk about the implementation initiative under the NIST grant to the AFS, how that's going. It's moving along.
So there's a cooperative agreement between the American Academy of Forensic Sciences and NIST to provide tools, training, and resources to the forensic community to assist with implementation efforts. So there's specific training that's available at no cost to the labs or to the end users, whether they're policymakers, lawyers, or scientists. There are also fact sheets that are being developed. There are 36 fact sheets that are currently on the website that distill a technical standard into lay terms that might be really valuable to a prosecutor, a defense attorney, a judge, or someone without discipline-specific knowledge. They kind of highlight the purpose of the standard, the key benefits of implementation, and that type of thing. And then there are also checklists, 36 checklists that are on the website currently that were developed this year with a lot of input from operational labs. Actually, Texas DPS participated in the beta testing for the checklist initiative, and also the New York State Police Lab System, Ray Wickenheiser and Brody Mills participated in that, and we also work closely with AFQAM to get input from those folks, just because they're going to largely be used by the quality managers. And those checklists are designed to provide a framework for a lab to document conformance to a standard and to identify maybe gaps so that they can monitor conformance to a standard over time. And Erica Zemak, who's here, Laurel Farrell will be at the AFCON meeting presenting a workshop next week on the use of the checklist, which we're really excited about. So there's a big reveal on checklists, but again, those are for use primarily by operational labs. But the fact sheets will be great for prosecutors, defense attorneys, and judges. So those are some of the resources that are available. And during year 2 of the cooperative agreement, there'll be 100 more checklists and 100 more fact sheets. So we got our work cut out for us. And that's all being done by the American Academy of Forensic Sciences. That's completely free to anyone. You don't have to be a member of the Academy to access those resources. So we're excited about that. Thank you. I didn't know I was going to be asked to.
I'm sorry, I should have warned that to you.
Yeah.
I should have warned you.
Yeah, the Academy website has been it's been redesigned this year, so people struggle to sometimes find that information. But if anyone here is having difficulty finding it, just send me an email and I'll send you a QR code so you can get there. And we'll also be doing a workshop at the Academy meeting in February on the use of the checklists. So.
Thank you.
And I should mention that work on the standards, that's SDO agnostic. So that is, although the Academy operates the ASB, which is one of the SDOs that operates in the forensic space, the training, and the resources, the fact sheets, and the checklists are for all of the SDOs that operate in forensics. So we've got resources for everything from NFPA. We don't have any ADA standards currently, but those will be developed. But heavily ASDM and ASB at this point. But it's anyone who's writing forensic standards, and those standards make it onto the OSAC registry. Resources are being developed to help with implementation.
Thank you.
Thank you. Update from the Association of Crime Lab Directors.
Dr. Stout sent his regrets, and he said that he will have an update in January. They don't meet every quarter, they meet every other quarter, and January will be the beginning of the legislative session, so he'll probably have lots to say. Then, did you have anything,
All right, so our next meeting will be the 27th of January, and then we're still deciding on April.
14th or 21 of April? It says either or. Is that because we're waiting to get feedback from people, or?
I guess, yeah. I don't remember.
It's so far off.
Well, we're trying to get you guys to schedule your life around our meetings.
Or if there are red flags on the 14th or the 21st of April, let us know. I mean, they do schedule annual meetings for various things, sometimes multiple years in advance. And then ultimately we'll go with what Dr. Bernard prefers. So if you have if you have a trial, or if you have a conference, or if you have spring in Paris or something that you're planning, let us know.
That would be nice.
Yeah,
Okay,
we have a strong preference for the 14th. If
Okay.
that works. Okay.
do we have anybody signed for comment, public? Okay. Do I have a motion to adjourn?
So moved.
Second?
Second.
All those in favor say aye.
Aye.
Opposed? Yes. Spring in Paris would be very nice. That doesn't seem to be on my